Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Robert L. Tsai, Professor of Law at American University Washington College of Law, and currently the Clifford Scott Green Visiting Professor of Law at Temple University Beasley School of Law. We will discuss his book, Practical Equality, which is published by W.W. Norton and Company. So welcome to the show, Rob.
Thanks for having me on your show, Brian.
Yeah, so I really enjoyed reading your book, which is so beautifully and cogently written. But for listeners who have not read it yet, I wonder if you could start by just talking about what you mean by practical equality. What is that? And how does the practical part modify the concept of equality?
Sure, I'd be happy to talk a little bit about the ideas. The way I use the term practical equality is I mean it to refer to a kind of backup plan to our usual way of thinking about equality, which is typically in more ideal or idealistic terms, right? So philosophers often talk about equality in terms of what basic equality demands. And these are very sort of idealistic terms in terms of thinking about what membership in a particular polity requires a particular community to give each member of that particular community. And so practical equality is a way to kind of break into this conversation by exposing first that we run into a series of difficulties when we talk in purely idealistic terms. To kind of show what those recurring obstacles are in the way we talk about equality in this idealistic way, and then to suggest that what we really need to do is to kind of develop a backup plan. So once we recognize these recurring obstacles and we run into them, how do we think practically about solving equality-related problems in other ways, and that's what the book is about: is to sort of talk about what these problems are in the ordinary way we talk about equality, and then show how kind of historically, when we've run into trouble on matters of equality, how we've developed sort of workarounds to those obstacles.
Right. So I wonder if you could give an example or two of circumstances where government or institutional actors have sort of implemented equality in the kind of practical way you're suggesting. In other words, how does this work in practice, as it were, and sort of how would we think about, or how would we identify, why this approach is the kind of most effective approach?
Yeah, absolutely. So let's start with an example outside of the court system. So on the question of slavery, of course, Americans engaged in a conversation that lasted generations over the morality and legality of slavery. And for most people who oppose the institution of slavery, they saw it in these very important, powerful, and idealistic terms in terms of what equality demands that we give each member in the society, right? And that's how most abolitionists talked about the problem. And the difficulty was that this position ran into any number of obstacles. A number of people worried, including liberals, for example, worried about the practical consequences of abolition. Right? What would we do with all of these former slaves? Would we have to give them exactly the same rights as everybody else? How would they be socially integrated? This led, of course, some people to come up with expatriation plans, including Abraham Lincoln first kind of believed that would be the best solution after some kind of emancipation. So the upshot is that this long conversation over the morality of the equality issue here kept running into a number of obstacles. And while it's very important to have this society-wide conversation, what we sometimes miss is that other people took more practical routes to try to minimize or reduce the suffering that enslaved people actually were experiencing. So the example here would be that enslaved people sometimes brought lawsuits themselves, and they repurposed common law concepts like self-defense, like assault and battery, kidnapping, as ways to try to sort of chip away at the institution of slavery. Now, none of these ways were the equivalent of arguing that slavery was a denial of equality, right? But they were different ways of sort of kind of talking about the problem, or at least parts of the problem, and different ways of trying to, as I sort of focus on in the book, reduce the actual suffering that people are experiencing. And that's really the main emphasis here in the approach, is that if there's more than one way of reducing that unequal burden, then what equality demands, I suggest, is that we talk about those other ways, because what pragmatism really kind of helps us to sort of sort out is that there could be more than one way to solve a problem. And if the outcomes are essentially similar, then we shouldn't fret about how we characterize the problem.
Right, right. Well, I mean, maybe you could identify some circumstances sort of closer to us in time in which we've sort of, or institutions have used kind of practical, pragmatic approaches in ways that achieved positive or desirable results in a way that more kind of holistic or more idealistic approaches might not have been effective.
Absolutely. So I kind of range very broadly from older, out of sort of court situations to a lot of cases in the judicial system. And what I try to stress throughout is that justice is a sort of collective idea. It's a collaborative enterprise, and it requires a certain amount of compromise without kind of losing sight of what's important about equality, which is reducing these unequal burdens that we've been talking about. Now, some of the more recent examples that I try to cite where I sort of kind of endorse the outcome, maybe the most popular one, or the one that most people will have thought about, is the travel ban litigation. And I actually start out the book by dropping readers right into that weekend, where and there wasn't really even an announcement, but people just sort of realized late Friday afternoon that something strange was happening, right? That the administration had quietly started to enforce this travel ban against travelers from a bunch of Muslim majority countries. And my point of dropping the readers into that weekend is to just remind people how chaotic that was. There were people who made plans to have their sick babies come to the United States to get care, and suddenly those plans were disrupted. There were people that had long-standing plans to come to the United States and to work or to study or to visit family, and suddenly people were being pulled off the tarmac. And so this initial kind of entry to the travel ban litigation is meant to sort of set up the reader to start thinking about these unequal burdens. But what I really try to defend is what happens earlier in the case. By now, everyone knows that the Supreme Court approved the third version of the travel ban, but a lot happened leading up to that. And what I try to do in the book is to talk about how the lower court judges, when they confronted, especially the first version of the travel ban, most people thought that the ban was really a denial of religious equality, because the president had for so long said that Muslim people were, as a group, more dangerous than other groups, and this ban really seemed to be infected with that religious animus. But what we immediately see in the litigation is that the judges have some trouble, and this is a three-judge panel in the Ninth Circuit, one of the more liberal circuits, have trouble rallying around that idea. And what they end up doing is they end up issuing a unanimous decision on alternative grounds. This is the fairness grounds. They say that the ban violated due process because, in a number of ways, it failed to give travelers adequate notice of some pretty important changes to their expectations. And so that's an example of what I call doing the work of equality through other means. And I think that this is kind of an excellent example of what you should try to do when you have trouble resolving a case according to kind of the traditional equality principle. Is I say that there's a duty to look for some other way to reduce those burdens.
So one of the things I really liked about your book was the way that you used examples of circumstances where the courts kind of failed to do this to explain how and why this sort of practical, pragmatic approach to equality is important. I wonder if you could kind of identify and talk about some of the failures and what they tell us about how we ought to think about approaching this question.
Sure, this is great. I do talk about a number of failures. Probably the biggest failure that I spend quite a bit of time in the book talking about is a case that will be pretty familiar to those who teach criminal procedure or otherwise work in the kind of criminal justice area, and that's the case of McCluskey versus Kemp. This is a death penalty case that is handed down in the mid '80s, and it's a pretty devastating case. What happens is that once the death penalty is sort of reinstituted, there's a fairly sophisticated study that is conducted on all the sort of death eligible cases that are handled in the state of Georgia, and what the study shows is a very disturbing pattern of racial discrimination. And there's a couple of different ways of kind of understanding the data. One is that Black defendants are significantly more likely to get the death penalty. The other way of understanding the data is that somehow the system seems to value white lives more than Black lives, and so that consistently, if there's a white victim, then the perpetrator is more likely to receive the death penalty. But in any event, either interpretation raises a serious concern about inequality in the criminal justice system, that some people are being put to death in this sort of unequal way. Well, this case ends up giving the Supreme Court of the United States huge fits, and it's decided on very narrow grounds, 5-4, against the challenge. And the case is disturbing in a lot of ways, but I'll just focus on the fact that when I went back and looked at the sort of memos, writings that went back and forth between the justices, it's clear to me that Justice Powell, who at that time often was understood to represent the center of the court, someone whose vote a litigant really needed to try to pick up if they wanted to have a chance to win, got really obsessed with the possibility that if the defendant won in this case, in other words, that if he prevailed on this equal protection claim, that it would bring the entire criminal justice down, right? He saw, in other words, he saw a slippery slope. He saw no way around the slippery slope. And as a result, the defendant had to lose the case. But what's terrible about the case is also that he doesn't just lose, they issue a kind of decision that tries to insulate the entire criminal justice system, or at least all death penalty cases, from future equality challenges of this sort. In other words, what they do is they end up manipulating the legal standards to say that unless you can identify a specific human being that is acting with malice, then there's not going to be anything that the courts are going to be able to do about these kinds of racial disparities. And this is a kind of burden that is pretty hard to meet if this sophisticated study isn't going to do do the trick. Now, why is this case a lost opportunity, though? Because that's how I talk about it in the book. It's hard to sort of offer, engage in kind of what ifs, but I do pose the question, which is that what if there was another way to kind of handle the issue? Could it have gotten Justice Powell to kind of soften his the whole world is going to end kind of attitude? And the alternative that I propose isn't just out of the sky, but actually something that's contained in the defendant's own briefs. There was an argument, I think, there about fairness, that they didn't push perhaps as hard as they might have. There was some evidence in the case that there were almost no standards governing when a prosecutor could seek the death penalty. That was true in the jurisdiction where the defendant came out of, in the sort of Fulton County area. But there was also some suggestion in the case that a lot of other counties either didn't have procedures, or at a minimum there was a kind of huge range of different ways in which prosecutors' offices handle death-eligible cases. And most people would say today that prosecutorial discretion is probably the number one factor in creating these kinds of disparities. So this would have been another way of trying to handle this case, to try to reduce some of these inequities by reframing the stakes in terms of fairness. And I talk a lot about in the book how sometimes by recasting an equality issue in terms of fairness, kind of like the travel ban situation, you can sometimes get people to sort of soften their objections, and I wonder if that could have been done in this case, because certainly the remedies would have been very different.
I wonder if you could speculate or reflect a little on a recent dispute that struck me while I was reading your book, which was the sort of situation in the Masterpiece cake shop case. Did the court take a pragmatic approach there, or could it have done better, in your opinion? In other words, how should it approach kind of questions of that kind, where equality and fairness seem to be really the kind of fundamental background question?
Yeah, that's a really tough case and a great question. So the thing about practical equality as an approach is it's not going to give you a kind of automatic answer. It's more of an approach to help us sort of think through disputes that are presented to us that appear sort of facially as equality problems, and to try to invite us to see if we can try to solve them in other ways once we run into difficulty. But it's not going to necessarily work in all cases. The Masterpiece cake shop one is a tricky one, because you actually do have a whole bunch of different conflicting values, right? It's often understood as a clash between equality on the one hand, that of gay and lesbian people, and then religious believers, sort of free speech or right of conscience claims on the other. But actually, I think it's more complicated than that. I actually think that there are equality claims on both sides, right? Because if we're sort of fair to the religious objector here, that religious objector isn't just a solo actor. It's an individual who is part of a broader religious community, right? And it just so happens that the First Amendment is the kind of strategic vehicle for pressing the claim that he or she has, but that individual is really representing kind of a community with a similar set of beliefs. And so to that extent, they see it not just as a conscience or speech issue, but also as an equality issue. So that case is complicated. I mean, I think you're right that the outcome is a kind of a practical outcome, but it was one that ended up being unsatisfying for, I think, people on both sides, right? Because it ends up giving the bake shop owner only a kind of temporary reprieve based on the specific interaction that he had, it didn't really lay down any broader principles, either in terms of equality or in terms of the speech religion issues that were posed. And, it seemed that Kennedy couldn't come up with a good framework, or maybe couldn't come up with one, right, that convinced enough colleagues to kind of join him in doing it. And so it's a kind of a practical outcome that's more like what I describe in the book as a deferral, where they just kind of find a way to kind of kick the can down the road a little bit. That's the way that case sort of feels to me. But I'll tell you what, I don't know if you want to talk about this, but actually a more recent case where I do think reflects a practical approach to a problem that really does have kind of egalitarian effects is the census case. I don't know if you kind of follow that. Yeah, so the census dispute is one where the challengers to a decision by the administration, specifically the Secretary of Commerce's decision to add a question inquiring about whether the respondent to the census is a citizen of the United States, was grounded in egalitarian concerns. Right. The fear here was that if you asked people whether they were a citizen, and this became publicized, then you would get fewer responses among undocumented migrants, and you would also get fewer responses from Hispanic citizens of the United States. And so this was the theory of the case, that there were serious equality problems here, and that the administration added this question, or wanted to add this question, specifically to depress the turnout or the responses from these particular communities. Now, why would they do that? Well, as the theory continues, because the information that would be extracted from the census would then be used for allocating federal funds and for determining representation, right? And that this would help the GOP in sort of its designs for to engage in partisan entrenchment. So this is a theory, right? Now, what's interesting is that everyone who watched the oral argument in front of the Supreme Court thought that the challengers had lost this case. They couldn't pick up Roberts' vote. Everybody else, most others seemed hostile, and that it was just a matter of how badly the challengers would lose. And then what we learn is, like, right at the end of the term, the Supreme Court issues this kind of shocking ruling where Roberts somehow gets peeled off from his usual colleagues on the right and joins the four liberals in stopping the administration from adding the question. What's the grounds that he uses? It's actually the rule of reason. What I talk about in the book is rule of reason. But technically, it's the use of the Administrative Procedures Act, which requires that the government give reasons for certain agency actions, right? But this is a statute that embodies a lot of what we know about these older principles that I collectively describe as the rule of reason. Things like a decision has to be a true decision, not a fake decision, that a government decision has to be rooted in empiricism, not sort of wild speculation. And this is kind of a stunning decision. And I actually think it's a really great example, and a really recent one, of the approach I talk about in the book. Now, we won't know for sure until sort of Justice Roberts either talks about the case or, he opens up his own files for historians to look at. But I really do think that this is a pretty good example, at least looking at it from outside, of a situation where a lot of people felt like there were equality stakes here. There was no way they were going to be able to issue an equality decision. Part of that has to do with the procedural posture of the case. The broader equality questions were not taken up by the higher court, but that they felt these concerns, and they found this. They used the rule of reason as a way to kind of give us an egalitarian outcome by stopping the administration from engaging in what many people thought was partisan entrenchment.
So, Robert, I want to return to this idea of the rule of reason, but first, I wanted you to talk briefly about like hard
Okay.
cases, right? Like, what do we do with like racists and fascists? And I mean, how do we think about people like that or odious ideas like that in relation to kind of pragmatic, practical equality?
Right. Those are really hard questions. I do write a bit about kind of grassroots mobilization on the right and the left, and in my writings about the figures on the right, I do really try to stress how sort of organized, how frightening, how illiberal. Not everybody, but a number of those folks really are. And I still think it's very important for us to confront um, those kinds of problems head on. The approach I stake out in the book is really a kind of a backup argument that there will be moments where other kinds of arguments, other kinds of approaches will be good substitutes. What I call it will allow us to engage in principled substitution of one idea for another. But there will be other instances where it won't be a good substitute, right? So sometimes we really do need the powerful rhetoric of equality to meet the racist challenge head on. Now, in politics, I think we're much freer to do that, right? We're much more able to say, hey, what you're saying is ethno-nationalist, it's xenophobic, it's racist. I think that conversation is very important. Those conversations need to go on. We also have to recognize that there are people, including people in positions of authority like judges, who will have concerns about that form of discourse. Um, uh, they worry about being branded as a racist or as a fascist kind of willy nilly. They worry about the downstream consequences of such a finding, right? That what do you do, for example, if you say that the president's signature issue is racist and xenophobic? Most right. I mean, most of us think that a lot of the things that he does is racist and xenophobic, but lawyers and judges have to think about, well, what are the legal consequences of that finding? Would it mean that everything else that he does afterward in a given area is all tainted, right? Um, and I think that these are the kinds of practical legal consequences that other people who are more constrained in these matters start to worry about. So I'm all for having wide open, rollicking conversations about fascism and racism. We've got to be able to do that. But we've also got to be able to recognize that sometimes the way we have those conversations can actually become impediments to rendering justice.
Okay, well, let's return to your conversation about the rule of reason because I found that a really fascinating and sort of, I mean, subtly, potentially controversial part of your book. So I wonder if you could talk a little bit about how equality and especially kind of pragmatic equality informs our concept or is informed by our concept of the rule of reason and what that would mean in practice and whether a kind of more robust expectation of reasonableness on the part of the government might potentially anyway change the way we think about a lot of legal standards. I mean, I couldn't help but ask myself, like, what does this do for like the rational basis test, for example?
Right. So I think this is great. The argument basically in the book is that sometimes reasonableness can work as a pretty good substitute for equality if our focus is in reducing unequal burdens. That's not going to work in all cases, but I talk about a number of situations where, like the census case, like a case involving uh, uh, mentally disabled individuals who challenged an ordinance that said, for example, that they couldn't live together in a particular area of town. Um, that that sometimes it can do some of the work of equality in this other way. Where I start though is I start out by showing that reasonableness actually is something that runs throughout our constitutional tradition, right? If we pick up the Constitution, our pocket version of the Constitution, we'll see, right, that it shows up in a number of places, and most notably in the Fourth Amendment, where we say that we have the protection against search and seizure based on reasonableness grounds, right? That the police officers can't put their hands on us or inside our things unless they've got a reasonable justification for doing so. So that's where I start. As I say that reasonableness runs through in our entire constitutional tradition, including what you described, which is that every governmental action has to be minimally reasonable. Now, sometimes what we see is that the focus on reasonableness in terms of its emphasis on empiricism, on its demand that we give genuine grounds for taking action as opposed to false ones, can actually do some similar work that the principle of equality does. We talked a little bit about this already in the census case, but I also talk about other situations where that's true. Now, I suppose it's controversial in the sense that a lot of people have different views about what's reasonable, and I get that. I think that's right. And on top of that, what's reasonable has changed over the years, right? That what we find today to be unreasonable, people in an earlier generation probably generally thought was perfectly fine. I think that's just part of the animal that we have to deal with, right? And yet we never given up this idea that there's something very basic about reasonableness and about the work that it can do. We've never said, nope, this is something that we're going to kind of throw out. So I try to extract from this tradition it's kind of egalitarian promise, if you will.
Mm-hmm. So, Robert, in closing, I wonder if you could reflect on things that maybe you were thinking about while writing the book that you weren't necessarily able to include, or maybe that are kind of baked in without being explicitly discussed or addressed in the book itself. In other words, sort of to the extent you sort of have a kind of galaxy brain outside the book, way of thinking about the questions, are there things you'd want to add for listeners who are going to be reading the book, and maybe things they could think about while they're reading it?
Yes, there are two things I sort of I wasn't able to, I think, grapple sufficiently with in the book. And I'll just briefly mention them both. The first is the sort of broader kind of intellectual tradition. So, for your listeners who love intellectual history, I originally had much more in here about the tradition of pragmatism. This is really, America's major contribution to philosophy is the notion of pragmatism. And pragmatism in the United States has taken a lot of different twists and turns. And in a lot of ways, it's gotten a little bit of a bum rap with how a number of legal theorists have used pragmatism. And I'm here, I'm, gently, pushing back on Sunstein and Posner and everyone else, and these giants that have really taken pragmatism in a very hard law and economics direction. And we've gained a lot from their work and those insights. But it's funny because I would have never thought of myself as a pragmatist until I started doing the work associated with this book and kind of immersing myself in those readings. And I guess what I tried to bring into the book, but which I wasn't able to sort of explore kind of thoroughly, is the sort of humanistic aspect of that broader tradition, right? William James and the John Deweys and even Holmes, who focused on how the life of the law has not been about logic but about experience, and Cardozo's openness to history and sociology. I mean, so there's this broader openness to ideas, this sort of a demand that judges live among the people whose disputes, right, that they're trying to resolve. All of this I wanted to sort of bring in, but didn't really have a chance to sort of say why it's so important to have that vision of judging as an alternative to sort of the judge as a kind of technocrat, if you will. So that's one thing that I'd love to take this in that direction. The other thing that I think I wasn't able to fully do, although you get little bits of it here and there, is to kind of put the ideas in the context of the possibility of a democracy in decline, right? There's a way in which a lot of people have been really thinking hard about where our constitutional order is right now, why it is that we're so susceptible to popular movements kind of from the far right as well as the far left, how these ideas either would work or wouldn't work in light of the kind of broader democratic condition in which we find ourselves. So those are the two kind of directions that my own work is kind of trying to push these ideas toward. And I love talking to you about it today, and I hope to hear from some of your listeners down the road about these.
Absolutely. Well, Robert, thanks so much for coming on the show today. It's been a delight to talk to you about your excellent book, and I'm really so glad I went to the panel about it at Law and Society, which is where I learned about it. So thanks a lot.
Thanks so much for coming, and thanks for having me on your show.
The most powerful man in the world is also mortal. We know this all too well in America. 1 in 5 American vice presidents has had to rise to the duties of commander-in-chief. 1 in 5 has had to take on the responsibilities of the most powerful office in the world. For this job, after 5 months of reflection, George Bush made his personal choice, J. Danforth Quayle. Hopefully, we will never know how great a lapse of judgment that really was.